matter on Capita, Customer Management Limited and another, and Ali and another.
May it please your Lordship's Your Ladyship, I appear on behalf of Leicestershire Police, along with my learned friend Jonathan Davis. Against us, on behalf of PC Hextall, is my learned friend Douglas Leach. And then in the Ali and Capita appeal, on behalf of Mr Ali, Ijoma Omambala and Deshpal Panasar for Mr Ali, and my learned friends Andrew Burns, Queen's Counsel, and Lucinda Harris on behalf of Capita. Now, in the present appeal, in the Leicestershire appeal, of course, both parties are dissatisfied with something that was decided by the ET and by the EAT. Can I turn straight to to PC Hextall's own appeal? That's against the remittal order and the terms of the remittal to the Employment Tribunal, or to a different Employment Tribunal. That ran counter to the joint position of the parties in the event that PC Hextall succeeded and Leicestershire Police failed before the appeal tribunal. And so we accept that if we're entirely unsuccessful in this court, PC Hextall's appeal in this court must succeed, on the basis that he wishes a remittal to the original tribunal for an assessment of compensation. And then looking at the position of the two sets of claimants, just zooming out for a moment, we would observe that their facts are very similar. The types of claim that they bring, the basis on which they bring them, and yet, in relation to materially the same predicament, they can't agree between them whether their treatment amounts to indirect sex discrimination or direct sex discrimination. So one set of claimants must be wrong. And we go further, we say they're both wrong. We say this is an equal, it used to be called an equals pay claim, really an equal terms claim, and I'll come on to that in a moment. So starting with the scheme of the legislation relating to sex discrimination and equality, we're of course in the realms of Part 5 of the Equality Act 2010, and that's the part headed work. And that part of the Equality Act takes two different forms in relation to sex discrimination. So there's sex discrimination in the treatment at work, which is Chapter 1 of Part 5, where the Employment Tribunal has exclusive jurisdiction. It can grant a declaration, award compensation, including for injury to feelings, and make recommendations. And there's entirely parallel jurisdiction in relation to sex discrimination in the terms of work. Entirely parallel and separate. They used to be called equal pay claims. Strictly speaking, they're claims relating to the sex equality in terms and pension rules. Now, in relation to those kind of claims, both the courts and the tribunals have jurisdiction, and the tribunal is entitled to make a declaration of rights and award or make orders for the payment of arrears of pay or damages. So it's effectively a contract claim. There's no compensation for hurt feelings, of course, in that type of claim, and there must be a real comparator. There must be a living, breathing comparator in an equal terms claim, whereas in an equal treatment claim, in sex discrimination or indeed other forms of discrimination, the comparator can of course be hypothetical. Can I turn then to the position of police officers within Part 5 of the Equality Act? I'll do this at perhaps a little more length than I would normally do, because it's our submission that both of the tribunals below seriously misunderstood the position of police officers and their terms. They're not employees. There's no contract of employment or service. They are people who hold office under the Crown. They hold the office of Constable with statutory terms and conditions of service and terms that derive from statute. And so for the purposes of sex discrimination in treatment only, so not the terms claims but the treatment claims, Section 42(1) of the Act deems them to be treated as holding employment by the Chief Constable or by the local policing body. I should say we've handed up I'm afraid, yet more paper, but a very small clip of legislation with a multicoloured front, which contains a number of the sections that weren't in the legislation bundle. They're not particularly controversial in the main, and the court will find section 42(1) on page 2. So that's the deeming provision for the purposes of a treatment claim, a sex discrimination in treatment claim. And here we say that PC Hextall, if it were a treatment claim, would be within section 42(1). Doesn't particularly matter which one, that simply tells you who the respondent to the claim would be. There's a different route for the protection of police officers in relation to equality of terms claims, sex equality of terms claims. And that's because section 79(8) of the Equality Act provides a different, well, it excludes section 42, and there's a different route by which officers then fall into chapter 3, the equality of terms claims. So the court will see section 79(8) extracted on page 2 of the clip of legislation that I handed up earlier. So it disapplies section 42 for the purposes of an equality of terms claims, and it in fact makes the holding of the office of constable to be treated as the holding of a personal office. And then section 80, subsection 2b of the Equality Act, and that's at tab 14 of the legislation bundle. So 82b tells you how you're going to...
So which page, which tab?
That's tab 14, my lord. Literally be 4 or 5 pages into that tab.
Is this the joint legislation bundle?
Well, it is. If you only have an electronic copy, so I don't know how it's supposed to look in the field, but
Joint legislation, not on the back spine. Thank you. Tab 40.
yes, it's section 80, and we're looking at section 82b. The terms of the person's work are B, where the person holds a personal or public office, the terms of the person's appointment to the office. Of course, a police officer holds a personal office. So the terms of work to be compared to the purposes of an equality of terms claim are his or her terms of appointment. I hope an essential reading list made its way to the court on Friday, because that would have directed the court to the document we'll come to in a second, which is an agreed note of police officers' terms and conditions. I fear from your Lordship's expression it never reached.
There was a lot to read. There was a lot to read.
That's why I had asked my clerk to dispatch to the court an essential reading list. I fear I perhaps ought to have checked again that it had gone. Well, just for your Lordship's and your Ladyship's reference, page 171 to 176 of the supplementary bundle. So I fear that may have been perhaps less focused in
Which
the
tab?
court's reading.
Tab 29.
Is this the joint supplementary bundle of documents?
No, there should be a Hextall supplementary bundle.
Like this. name
Yeah.
tags. Page 171.
Yes.
This is the
I don't know any tabs in there. I fear since I'm working on it, I don't have the physical version of these documents. But it's 171 to 176.
Agreed note on officer status and pay
Oh,
entitlement.
yeah, that's right. That's a short but essentially accurate summary. I don't know if the courts reached that document in the court's reading. That is an important
which particular passages here do you want us to concentrate on?
Well, perhaps it's better if I just go through it fairly briefly on my feet, because it's a fairly lengthy document. I think it accepts what I say, which is that police officers' terms and conditions derive entirely from Section 50 of the Police Act, 1996. Regulations made thereunder, which are the Police Regulations 2003, and a determination or determinations by the Secretary of State of the Home Department. So the Secretary of State fills in the gaps as authorised by the regulations made under the Act. And the meat of the terms of appointment of a police officer are contained in the determination. And that determination has numerous annexes. In fact, it's broadly a determination with annexes. It simply has a front sheet that says Annex A deals with this, Annex B deals with that. It's an introduction. And there are numerous annexes going through the alphabet and more, dealing with each of the relevant types of right, to, for example, leave, pay, holiday, etc., overtime payments. And the effect of Regulation 34.2, which is in the clip of documents I handed up, page 3. It's that small clip of documents. We say is potentially significant, but in any event, it's accepted that the Act, the regulations and the determination as amended are a complete code of police officers' rights and entitlement, with one perhaps small addition. So Regulation 34.2, one sees no allowances should be paid to a member of the police force except as provided by or under these regulations or approved by the Secretary of State. It's those words, the last 4 or 5 words I read out. And the amounts and conditions of payment of such such allowances shall be as so provided or approved. So I've gone through the provisions, namely the determination, etc., made under the regulations. In this case, there's a shared parental leave circular sent out by the Home Office, which appears to have been accepted below to have been, and we certainly accept here, to have been an approval by the Secretary of State. It's in perhaps unusual words, because it's promising to change the regulations and to provide a fresh determination or to amend the determination. But the parties accept that that is in essence an approval of a shared parental leave right and a rate of payment at statutory rate.
This is an entirely new point.
Not accepted.
It's not accepted then, but that's what we say it is, and we say it's
I'm just trying to
self-evident.
understand what you're doing. You rely upon 34.2
Well, yes.
because that, you say, gives a comprehensive content as to what the police officer is entitled to. It has to be as provided provided by or under the regulations,
Yes.
or approved by the Secretary of State.
Yes.
That's, I'm just trying to get your central point here.
Yes.
So you're saying we have to find, whatever we find the police officer is entitled to, it has to be within the regulations or as approved by the Secretary of State.
Yes. There are no implied terms, as there would be in a contract of employment. There's no discretion except where discretion is provided for by the regulations or determination. The police officer, when he or she wants to know how much leave I have, how much overtime do I get, how is it paid, when is it paid, he or she will look at the regulations and particularly the determination as amended from time to time, and he or she will find their
What you
rights.
call the determination is covered by these words, approved by the Secretary of State.
My Lord knows that, in fact, the previous words, as provided under these regulations. So under the regulations is made a determination, the main one in 2003, and it's been amended from time to time by successive Home Secretaries to improve or change rights for police
But
officers.
is your point that it's not, the determination has not yet actually been amended to introduce shared parental leave, but that everyone has assumed that because the Home Office issued this circular saying that they were going to do it, that amounts to approval by the Secretary of State of shared parental leave, even though it's not yet found its way into the determination?
That's correct. We accept that it's possible for the Secretary of State to, outside the determination, approve the making of certain payments or allowances. So the best we can say in relation to how this right has arisen is that it's been approved by the Home Office circular that's in the...
So you accept there is a right?
We do.
Oh, you
Lord,
do.
we accept that. So I think what's accepted between the parties, and I hope this is not going too far, is that, well, however it's happened, there is a shared parental leave right on the part of police officers, and it is paid at only the statutory rate. I would go further and say it can only be paid at the statutory rate. It can only be paid at the statutory rate. So on the basis of that, I would then pose...
It can only be paid at the statutory rate
Yes.
because of 34(2. Is that what you say?
Well, my Lord, because of the scheme of the Police Act regulations and determination and belt and braces of Regulation 34(2.
Because that's the only rate that's been approved by the Secretary of State.
That's correct. That's correct. And it's quite clear, we say, from the scheme of Section 50 of the Police Act, the police regulations and the determination, that this is intended to be a complete code, except where you have additional approvals on the side. So we have this additional approval in relation to shared parental leave and the statutory rate of pay. But there's no other way to imply, add or see a discretion on the part of police officers to pay more. So for example, police force A can't compete with police force B by saying we're just going to pay police officers or perhaps the chief constable more to poach or to encourage better candidates. There is a statutory framework and that is how police officers are paid, and that's how their rights arise, and not otherwise, save as approved by the Secretary of State.
Right.
You're not saying that overrides the equality clause, would it? I mean,
No.
that has to be subject to findings of the court that the
Yes.
terms have to be modified.
That's exactly right, my lady. That is one exception I was going to come on to, and it arises in this way. Supposing the Secretary of State, in a determination, created a discriminatory term, so provided on the part of male officers some sort of bonus, some sort of extra payment, or paid them differently, then I'll come on to how the equality, the equal terms part of the Equality Act works, but in essence, the deemed equality term would equalise and level up the terms of female officers in those circumstances. So that's an exception to this rule, because in law there would be something like a quasi contractual amendment in effect, be a deemed amendment to the terms by operation of the sex equality clause.
Could that only be for some women police officers, or would it have to be for everyone on a certain grade, up and down the line?
It would work in exactly the same way, my lord, as it would work in a conventional equal pay claim amongst employees. So exactly the same way, there'd be a levelling up, and then you could have a piggybacking of rights between men and women. in the police force.
Can you identify for me what you say is the fundamental misunderstanding?
Yeah.
After you say the employment tribunal.
Yes. If the court turns to, in our core bundle, page 110, that should be the employment tribunal's judgment. And this, do you see near the top of the page, it's paragraphs 24 and 25, so we're at the tail end of 24. About 3 lines down, PC 836 is I would add the word female, police constable who took maternity leave and was paid enhanced maternity pay. What does matter is that her contract, and that's of course perhaps a misunderstanding, her contract and that of the claimant are the same in all relevant respects. His contract includes a right to enhanced maternity pay, wrong, we say, but obviously he will never get it in practice because only women can. And they make a similar point wrongly in paragraph 25. Before I go to why that's quite plainly wrong, can I pick up a similar passage in the EAT's judgment where they make...
I just want to read this to you.
Yes.
The PC 836 is a female police
Yes.
constable who took ML and was paid enhanced NP. Which part of that is wrong?
That's right.
That's right. What does matter is that her contract and that of the claimant are the same in all relevant respects.
But there's no
Is that
contract,
right?
of course, but
Is that right or wrong?
that's wrong. That's wrong.
In what respects are they different?
Well, if the court would take up that small clip again that I handed up before the beginning, page 3. There are 2 provisions there that make quite clear why that's wrong. So Regulation 29, maternity pay. The Secretary of State shall determine the entitlement of female members of police forces to pay during periods of maternity leave. And then there's a provision in relation to the creation of maternity leave rights. That's Regulation 33(7). A female member of a police force qualifies for maternity leave in such circumstances as shall be determined by the Secretary of State. One, of course, then needs to ask, what does the determination say? And that's over the page. Needn't go to both of them, but Annex L is on page 4. And I should say this is as amended. Like legislation, the Secretary of State amends in a very similar way. Unlike legislation, there's no official source of the updated version. So frankly, many of us go to the Police Federation's website where they keep a nice up-to-date version. So I take it this is not in serious dispute, but this clearly relates to the rights of a female member of the police force who satisfies certain conditions as to the taking of maternity leave. And these provisions cannot be read in any other way than to say that female members of police forces, female police constables, have a right to maternity pay and leave. Male police constables do not. There is no other way, we say, of reading Regulation 29, 33(7), and Annex L, and if you turn over the page, Annex R, than to find there's a disparity, a clear intentional disparity between female and male members of the police force in this respect. So a male member of the police force does not have even a meaningless maternity leave and pay right. He has no maternity leave and pay right. So his terms of appointment, or to borrow the incorrect phrase of the tribunal, his contract, but let's stay with the correct phraseology, his terms of appointment are not the same. And it will immediately be seen that is why he is paid less in the material respect, in the material circumstances, than a female officer taking maternity leave. The opportunity to correct that error was before the Employment Appeal Tribunal. Mr Davis and Mr Leach put in the agreed note that I briefly referred the court to. He put that, they both put that before the Employment Appeal Tribunal as a joint document. It appears not to have sent its message quite home. As we see at page 82 of the court bundle, the Appeal Tribunal makes precisely the same mistake, despite their submissions. So page 83 of the bundle is where we find paragraph 25 of the Appeal Tribunal's judgment.
This is page, what am I now?
It's in the core bundle,
Core bundle.
for PC Hextall.
Page 80.
Page 82.
82.
And if we start reading from line 4, just below the D, the shared parental leave provision, these are the incorrect words, as do the maternity leave and pay provisions, apply to both men and women police officers.
Sorry, I just don't have that. Page 82.
Oh, I'm so sorry.
Which,
It's 82 by order of the, it should look like a judgment. It's page 82 of the
which paragraph?
paragraph 25. It
Yes.
starts with the PCP.
Yes.
4 lines down, the
I
shared parental leave provisions, and then as do, the wrong bit is, as do the maternity leave and pay provisions apply to both men and women police officers. Plainly wrong. Plainly wrong. Surprising, we would say, given that the learned judge referred to both Regulation 29 and 33.7. If you turn back to page 74 of the core bundle, the learned judge sets them both out accurately, but says nothing about them. No wonder the Appeal Tribunal and the Employment Tribunal couldn't accept this as an equal terms claim, because an equal terms claim requires an inequality of terms. If they wrongly tell themselves that there's an equality of terms, they wrongly reject an equal terms claim. That's the short point in this appeal. And I shall now spend the rest of my time dealing with the longer point, if I may.
Right, so you say this is really, on proper analysis, an equal claims, an equal terms claim.
That's right, yes. And the reason both tribunals have rejected it is because they say the terms are already equal. I ought to develop that by going through how equal terms, and this is of course gender equality of terms claims work.
Yes.
So we start with section 66 of the Equality Act. So that's tab 14 again. I think in the legislation bundle we're going to be in tab 14 for a while. It always strikes me that colour coding the bundles would help, but I never think of mentioning it at the right time.
We can mark the spine.
Yes,
That-
well,
that's extreme.
I'm very sorry to hear that hasn't happened.
Anyway. Legislation bundle, yes. Which tab is that in?
Tab 14.
Yeah, we'd best go back.
It may be worth finding some space on the bench to leave the legislation bundle out, if there is space, I don't know. So if the court can then move to section 66, and this is the core of the equal terms claim. It's the sex equality clause.
Yes.
So if the terms of A's work do not, by whatever means, include a sex equality clause, they're to be treated as including one. I have to say, pausing there, I don't think I've ever seen a sex equality clause in a contract of employment. I'm sure some employers must include them, but I've never seen one. But they exist by virtue of section 66(1). And then what's the effect of the clause? It has two effects, and they're contained within section 66(2). Sex equality clause is a provision that has the following effects. A, if a term of A's is less favourable to A than a corresponding term of B's is to B, pausing there where B is of the opposite sex, A's term is modified so as not to be less favourable. So if men and women are paid different rates for like work, or work of equal value, etc., or the same work, they will be paid the same rate. Because this clause will operate to level the rates, and it levels the rates up. Just pausing there, the scheme of the Equality Act, I'm sure this is common ground between all council in this case, the scheme of the Equality Act in the equal terms provisions is to require a term-by-term comparison. So you don't say, well, the men have these rights and they're pretty good, the women have these rights and they're sort of just as good when you balance them up. You look term by term, and where there's an inequality, you level up. So that causes an inflation of terms, because one can see a piggybacking of rights, one against the other. And the scheme of the Act is to disincentivise inequality of terms by making it expensive, because it causes inflation in that way. The second type of effect of an equality clause is what's relevant here. If A does not have a term which corresponds to a term of B's that benefits B, A's terms are modified so as to include such a term. So he gets a corresponding term, a corresponding benefit to that of the female officer. So, but for what I'm going to come on to, PC Hextall, to pick up my lady's point, but for what I'm about to come on to, PC Hextall would benefit from a levelling up of Regulation 29 and the associated right under Annex L, and of course the payment rights under Annex R. So he gains a corresponding benefit, but for an exception I'll come on to. So that's how an equality of terms claim would work. Neither tribunal got this far because they thought the terms were already equal, of course. I should say that corresponding term, or the correspondence that's required, is not a carbon copy. It's not a cut and paste of the term of the comparable female. Because of course if you did that, you'd fall into the error that the tribunals have made in thinking, well, they both got a term relating to the benefits available to female officers.
Right, so what do you say is the corresponding term in PC 836's terms and conditions for the purpose of section 66(2)(b)?
Well, we say there's a non-corresponding term in that she has the benefit of the maternity leave and pay provision.
Right, so the term that we're focusing on in her contract is her entitlement to maternity leave and pay.
Yes, as a female officer, which is not contained in the terms of male officers. Yes. But for the exception I'm about to come on to, a corresponding term would be found in the male officers' terms of appointment.
Well, you provided for him to have paternity leave.
That's the question.
And I'm trying to understand how it
Happily, we
works.
don't need to analyse how that would work, because we'll never get there because of an exception, I'll point out. But
Well, but you do, because their case is it doesn't work, and that's why this isn't an equality clause
well,
case.
how it would work is something along the lines of a male officer shall, on the birth of his child, or up to 24 weeks before the birth of his child is expected, have the right to take paternity leave and have full pay for 18
Yes, that's what
weeks.
you're saying. You're accepting it. Say it would be the equivalent the equivalent provision for the maternity
Yes.
leave and pay for the woman police officer
Yes.
would be matched by a paternity leave and pay
Yes.
on the same terms.
Well, with the same right to leave at the same time, of course, corresponding in terms of the date of the child's birth. So he could take the time before or after, before or on the child's birth, as with the woman. And he can go back, he can start as early as 24 weeks before that's due to happen. And he'd gain the benefit of payment terms as generous as those of the female officer. So 18 weeks full pay, potentially 6 further weeks.
But
at 90%.
the extent to which that the corresponding term or the term in the woman's contract would need to be modified would depend on how it happened to be drafted. Because if it refers to her having given birth, then you'd have to cross that bit out, presumably, when you try and transfer it into his contract.
Well, it would be when his child was born.
Yes, but that's one way of expressing it, isn't it? It could be expressed in other ways, which would make it more difficult to, or require more adaptation before it would make sense, in the sense that he would be able to make use of that clause if it was brought into his contract.
Yes,
or terms.
but for the exception, that's the exercise that would have to be undertaken, that a court or tribunal would have to determine what would be the content of that term.
You better show us the exception, haven't you, Mr. Bassett? Because looking at section 66 in isolation from Schedule 7 is a rather abstract discussion.
Well, the exception, we start at section 80, which provides for it activates Schedule 7, providing exceptions, and section 80, subsection 8, Schedule 7 shall have effect. And then we turn to Schedule 7 over the page, and we've so far referred to paragraph 2. I'll also refer to paragraph 1 in a moment. Paragraph 2 is the obvious one. A sex equality clause does not have effect in relation to terms of work affording special treatment to women in connection with pregnancy or childbirth. So that prevents the need to have an interesting discussion about how you would construct an equal term for a male officer, because you will never need to do that. So not in these circumstances, where they're provided by statute, or only statute. I should say, paragraph 1, we say would have effect if paragraph 2 didn't. Neither a sex equality clause and maternity equality clause isn't necessary to look at, has effect in relation to terms of work, affected by compliance with laws regulating the employment of women.
So where are you reading from now?
I'm so sorry, it's just above, my lord. It's paragraph 1, it's just above the provision I just read. Compliance with laws regulating employment of women, etc. The sex equality clause does not have effect in relation to terms of work affected by compliance with laws regulating the employment of women and the appointment of women to personal or public offices. And the alternative would rely on that provision.
You do alternatively rely on that.
Yes.
I'm just trying to understand what that means.
Well, it means that if you have laws such as regulations 29 and 33 and the determinations that are made under them, and you comply with them, or they're required to be complied with, that's how you arrive at the terms of work in question that are unequal on the face of it. The equality clause does not apply. Does not have effect.
I just don't understand what we're supposed to be concentrating on, where the real issue is. Is the real issue here that you're saying this is a terms of work equality case, because, subject to Schedule 7, the effect of paragraph 66 would mean that something equivalent to the maternity leave and pay would have to be included in a male constable's, male officer's contract, that's what we call it, because it's not there at the moment. This would rectify that, and therefore that brings into effect Schedule 7. That's the way it works, is it?
That's most of the journey. There's then the reason why you can't bring at the same time an inequality of treatment claim. But I just have one further point.
You haven't got on to that.
No.
We haven't got on to it. I'm just trying to stop to where we are at the moment.
Yes.
What is the position? So what we have to decide on this point is it correct to say, were the tribunal and the EAT correct to say that because the BC Hextall's contract did contain a maternity clause, although he couldn't take advantage of it, therefore there wasn't, as it were, inequality of provisions. That's the first point. If they were correct on that point, then we never get to section 66, as you say.
Yes.
If they were incorrect on that point, what is the position if, on its proper interpretation, section 66 wouldn't be capable of remedying that?
Well,
because they are so different. In other words, a paternity clause would be significantly or materially different from a maternity clause.
well, if we were to take the analogy of an employment contract where one can start drafting them as one wishes and agreeing with the employees, it would never be possible. It would never be possible to defeat section 66 by clever drafting alone. So you
By
could
what?
never draft. You could never draft a provision that didn't have a corresponding provision, a sister provision in the male employee's employment contract that could defeat the effect of the equality clause.
So you use section 66 to get as near as you can,
That's right. So the courts would have to struggle with.
but you can never say it's impossible.
It will never be impossible. It can never be impossible, because the reason why that provision exists is to comply with an EU.
Right. So this
treaty
point,
obligation.
so this whole point does turn on the initial factor, the fact that the fact that there's a maternity clause in both contracts. That's PC 836, as well as PC Hextall's. The fact that there is in both, is that sufficient to rule out an unequal treatment claim? It all hinges on the first point, doesn't it?
Yes. Well.
The whole of this part of the case hinges on
Yes.
that point.
Yes. Well, if there's an unequal term,
Is it sufficient to amount to an equal term, even though PC Hextall couldn't take advantage of it because he's a man, the fact that in his contract there is a maternity clause?
it doesn't have a maternity clause.
Well, it does. It does have a maternity, but he just can't take advantage of it. I mean, these are standard contracts, presumably. These are standard contracts across the force.
Well,
is that wrong? I mean, I don't know. Is that wrong? I'd rather assume that.
Can I ask the question this way? As you pointed at, police officers' employment status or lack of it, I mean, all the terminology is different, all the source of the law is different. You've pointed to the regulations and determination which say that maternity pay and maternity leave are only available to female members of the police.
Yes.
Whereas in a typical private sector contract, the employer may not bother to say any women qualify for
Yeah.
maternity. Does that make a difference? Suppose that the drafts person of the regulations left out the word female from entitlement to maternity. Would that affect this case?
Well, again, Lord, it would not be possible to defeat, in an ordinary contractual situation, Section 66 by simply missing out the word female and just saying employees, male or female, who take maternity leave are entitled to the following rights. Because, but for the exception, of course, you will have created an unequal term. Because the man could never take advantage of it. So clever drafting
I
alone.
think you're saying that the use of the word female is really neither here nor there. In truth, the Schedule 7 exception applies anyway. Is that right?
Well, I actually say that the word female is relevant because in Section 20, in Regulation 29 and 33(7), it's specifically only authorising a determination to affect the terms of female officers. But even if that were not to be seen anywhere in the regulation or the determination, the same answer would apply. Because if one transposes a situation to a contractual situation with employees, you couldn't either, by the inclusion of the word female or missing it out, defeat Section 66. And the equal terms provisions would, but for the exception, equalise those rights in some way that was appropriate to give comparable rights.
Well, does it turn on this then, that the difference between you and Mr. Hextall is whether it's possible to have a term in Mr. Hextall's contract, terms and conditions under the determination, which corresponds to a maternity pay and maternity leave entitlement. And they say it doesn't, because if his contract, if his terms and conditions had such a term, he would never be able to take advantage of it because he's never going to have a baby himself. And your answer to that is to say, well, that you have to struggle then to modify the term in B's contract in order to arrive at something similar in A's contract. But then it you say, and even though that would be a struggle, we don't have to worry about it because of the exception, but the struggle doesn't of itself mean that Section 66 does not provide a remedy, and therefore you say the only reason it doesn't provide a remedy is because of the exception, not because it's impossible to apply 66(2)(b), and therefore the mutually exclusive rule comes in and you can't bring a claim for indirect discrimination. Whereas what they say is you cannot operate Section 66(2)(b) because Mr. Hextall can't take advantage of maternity leave and maternity pay, however it's expressed, because it is, however expressed, limited to women, and therefore it's not a sex equality case, and therefore the mutual exclusivity rule doesn't preclude an indirect discrimination case. Is that where we get?
Well, if I've understood my learned friend's argument, he said he adopts what the two tribunals say, and he says that the terms are already equal. It's just that they're not of equal utility, so to speak. And we disagree on that because, firstly, they're not equal. Even if you were able to...
That's your fundamental point in your
Yes.
answer, my lord. You actually do say that the word female in Regulation 29 is critical from your perspective, because this isn't the same as a private sector where you get written terms of employment and they're all standard form. So a man may well end up with a standard form contract for employment, which has a provision for a woman, it just doesn't apply to him in relation to maternity leave. You say that the effect of 29 is that only female members of the police force have that right. And there's nothing comparable. That right is not transposed into anybody else's contract of employment. That's where I think you come from.
No, that's right.
That's critical to your analysis.
Well, it's critical to pigeonholing it into section 66(2)(b).
Yes.
But taking my Lord Justice Bean's example, supposing this were a standard form contract in an employment context,
Yeah.
and one had these terms in both without the word female, then arguably it'd be a section 66(2)(a) case where the term was less favourable, because it's excluding you've got to give birth, and that's going to be difficult if you're male. It matters not, because in the end, section 66 will have the effect that the equality clause will provide corresponding benefits.
I understand
To
all
equalise
that.
the terms.
So I understand what. So can you just help me though? I understand where you've got to on going from 29, regulation 29 through section 66 to schedule 7, paragraph 2. Can you just help me on paragraph 1? I'm trying to understand. You say you rely on this as well.
Yes,
Can you just? I'm just trying to understand exactly what this says. Now, we have to assume here there's a sex equality clause. Is that right?
No, well,
Section
yes.
66(1). This is
There'll always
assuming
be-
against you. If you're right so far, you don't need paragraph 1.
That's correct.
Right. So
There'll always be a section.
what are the circumstances in which you require paragraph 1 because you can't get home under paragraph 2? What are those circumstances?
Well, I don't see any circumstances where that would occur, but I simply say that.
So then why are we worried about it? It is confusing.
I don't want to confuse the court, but what I say is that we're in a special situation where these deemed workers, these deemed employees, are their terms of work are statutory. Their terms of work are made under laws that regulate, in this respect at least, the employment of women or the appointment of women to personal offices, because female officers appointed to the office of Constable, their terms will be regulated by provisions such as 29 and 33(7).
I understand. Thank you.
Well, I'm not clear whether you're making some particular point about constables and the application of section 66, or whether your point could arise equally if these were terms and conditions of private employees. I understand your point that because they're in the determinations, there's no flexibility there, there's no discretion on the part of a particular chief constable to vary the terms and make them more favourable. It has to be across the board. But assuming some big corporation adopted the same policy, everybody has to be on the same terms and conditions. Is there something specific about the fact that these are terms and conditions that are included in regulations that changes the way that section 66 applies? No.
Not at all. Not at all. Because the way this works is to squeeze police officers into the same category as ordinary workers under contract of employment. So you simply have to pretend that they are working under terms of appointment rather like contract of employment.
Right.
If I'm right so far, we've got the equality, sex equality clause working and but then being accepted by Schedule 7.
Yes.
What then? We say then you look at section 70. And that's how we get to the mutual exclusivity rule. That term, I can say, has been used twice on our side. Once in this context and once in relation, I made the same point at the beginning, to indirect and direct discrimination. In that context, of course, it's a conceptual mutual exclusivity, because the way the two are defined, they can't happen at the same time. But this is a legal exclusivity, section 70 in tab 14 of the legislation bundle. And we say, well, at the risk of providing an additional complication, can I didn't have a situation like this and there were some sort of defence for an inequality of terms, of course you would be in the territory of the provision above the one I just referred to, section 69, so defence of a material factor. And so the equality clause wouldn't work because you've got a non-discriminatory reason for the difference in terms, such as some sort of ring fencing agreement. You might have, such as I think in the Ali and Capita case, you've got people coming in with their contract terms inherited from other employers. So they may have unequal terms with female employees or male employees, the case may be, but you will have a defence there if you've got, if you're able to justify it. For example, because of the historical disparity and needing to ring fence people's rights. In that case, still, just because the equality clause won't have any effect, you'll still be in this exclusion zone in section 70. Not sure we get there in our case. We get to section, well, I've just described section 70, subsection 1b. You'll see there reference to the section 69 defence. We get to section 70, subsection 2. So neither of the following is sex discrimination for the purposes of the relevant sex discrimination provision. And then one then sees something very similar to section...
Now I've got
Yes.
something. We've got to the stage where the sex equality clause doesn't apply under Schedule 7, paragraph 2, or even paragraph 1, but paragraph 2, because it's concerned, the term is concerned special treatment to women in connection with pregnancy or childbirth. Why do you need to go on beyond that? Because you haven't got the sex equality clause now.
Oh, well,
So why do we need to go to section 70?
So if the court's with me so far, but for what I'm about to say, my own friend Mr. Leach would say, well, this is still discrimination. He would say it's indirect discrimination, and we've seen how that ended in the Employment Appeal Tribunal. We would say, no, since we've got this far.
Goes to indirect discrimination.
But this goes to discrimination. This goes to discrimination in the treatment at work.
Well, it's what you're saying, there are two different concepts here. There's the concept of section 66 applying, but an exception also applying, like in section 69 or in Schedule 7, paragraph 2. And if that is your situation, you're covered by section 66, but you can take advantage of an exception, then you benefit also from the mutual exclusivity clause, and it can't then also be indirect discrimination.
Yes.
But that, then you're dealing with a different situation where section 66 doesn't apply, not because of an exception, but because it doesn't provide a remedy for the particular, or it's the particular wrong, or it's just not a sex equality clause type case. And if you're outside the section 66 regime completely, then there's no mutual exclusivity and you're inside the equal treatment, direct or indirect discrimination.
That's right. You're either in the sex equality terms provisions or you're not.
Right. But you're still in them for this purpose, even if you're actually benefiting from an exception to them.
Well, as the police officer concerned, you're still in them, even if you don't benefit from them, for the reasons I've explained. And may I also say that it's important as well to remember in the way that the sex equality of terms claims or rights, I shouldn't say claims, rights apply. It's relevant to remember that this doesn't depend on there being a claim. So what my learned friend Mr. Leach can't do is say, I'm not making a claim of inequality of treatment, because this operates as a question of law, as a matter of law.
It's not at the option of the claimant, it's provided by law that they are mutually exclusive.
Well, the sex equality clause is working subject to an exception anyway in millions of contracts up and down the country. That just happens without claims. So you can't choose, so you're not going to bring a claim. So the exclusivity doesn't occur because you've chosen to bring one sort of claim and therefore you can't bring the other. You simply can't bring a claim because, as a matter of law, these provisions apply, or in our case, of course, then don't apply because of an exception.
Yeah, I'm still slightly lost on 69 and 70.
Yes.
Up till now, you've been dealing with discrimination in relation to terms of work.
Yes.
That you've been addressing, is that right?
Yes. Yes.
And if we end up with paragraph 1 and paragraph 2 of Schedule 7, that deals with that issue.
Yes.
Do I understand now that we need to go back to 69 or 70, not to deal with discrimination in terms of work, but to do with discrimination in relation to treatment? Is that the point?
That's right. That is right. We do need to go through 70 at least. 69 we don't need to go through. That's probably an unnecessary complication.
Can we just ignore 69?
We almost can. It's just there's a case in the bundle that relates to it, and that's
Let's
why
just deal with 70 first.
Well, I can certainly.
But 69 is another thing like paragraph 2 of Schedule 7, isn't it? It's a
Yes.
way round the equality clause, if the equality clause applies.
That's right, but one of the cases in the authorities bundle is on the predecessor provision, and it will look like an indirect discrimination claim because if you seek to defend a claim in relation to a sex equality clause by virtue of a material factor that you say justifies a difference in terms, you can't take a factor that's itself discriminatory on grounds of sex, whether it's directly discriminatory or indirectly discriminatory. So there is a case which I think will be referred to later in this appeal, but not by me, which looks like an indirect discrimination claim, but is really an equal pay or equal terms claim, where Section 69 was the issue. But that's how they got to the quasi-indirect discrimination test having to be applied by the tribunal. It's a case called Grundy, but so if you hear Grundy, remember Section 69.
Can you just deal with my point?
Yes.
We've got back to, sorry, keep on getting back to it. I got back to paragraph 1 and paragraph 2
Yes.
of Schedule 7.
Yes.
So that deals with the non-application of a sex equality clause
Yes.
in relation to terms of work.
Yes.
You now want to turn to Section 70.
Yes.
Do I understand that because you're no longer now dealing with the terms of work, but treatment?
That's
Is
right.
that the reason?
That's right. Yes.
Right, all right.
Because what you can't then do if you're in the equality of terms arena as a question, as a matter of law, is say, well, I'm not claiming that. I'm saying this is an equality of treatment. And the reason you can't do that is because Section 70 prevents that.
Right.
So my learned friend Mr. Leach can't say, well, I'm not asking you to look at the equality of terms provisions. I'm just asking you to look at it direct or indirect discrimination. Neither Mr. Leach nor Ms. Owenbala can say that, we say, because Section 70 will apply. And we're really looking at Section 70, subsection 2.
And when it says the relevant sex discrimination provision,
Yes.
which provision are we talking about?
Well, if your lordship turns over the page...
Just give me tell me.
Oh, sorry, it's the provision outlawing discrimination at work.
Yeah, which is the section?
Section 39.2.
Right, that's right.
Yes.
So we're now looking at section 39.
Yeah. That's the one that protects employees from being mistreated, from being discriminated against at work.
Section 39.2 is where? That's in the clip, is it?
That's in
That's
the
in the
clip of... Yes, it's on page 2 of the small clip of legislation.
Section 39, 39.2.
Yes. I should...
Yeah, we haven't seen
No. It's obviously an anti-discrimination provision in terms of employees, not just sex, but all the other protected characteristics as well. But for these purposes, it is the relevant sex
And
discrimination.
because, and so just pausing there, this covers in 39 a number of different situations. Paragraph, if you're right about the non-commonality of terms of employment point, to write about that, you get through to a paragraph, the schedule of paragraph 7, paragraphs 1 and 7. So 1 and 2. Then we're not concerned with 39.2a. That deals with 39.2a, doesn't it?
Yes.
It deals with 39.2a. So we've finished that point. And so we're dealing with, is this right, 39.2d?
Yes.
So the treatment point we're now concerned with is 39.2d.
Yes.
And you're saying 39.2d is defeated by section 70.
Yes.
Right. Now, I understand all that so far. Because you keep going back to section 69 and saying, well, it may not be relevant, it may be relevant. Let's just understand it. Is section 69 addressing the issue in section 39? So sorry. In section 39.2a
No.
or 39.2d?
No, it's not.
What is it addressing?
It's addressing the situation where the equality clause would have operated because there's an inequality of terms, but the inequality of terms is justifiable.
The oddity is that section 69 is where it is. It would have been clearer if it had been put in Schedule 7 as another instance of when the sex equality clause doesn't help you.
No, with respect, it's probably in the right place because it's fundamental to an equality of terms claim. It's the next question you have to look at in every inequality of terms.
So section 69 would be relevant to indirect discrimination. I probably introduced confusion, my fault, but section 69 is the defence, where you say there's some factor that I say justifies paying this woman less than that man, even though they do the same job. But I thought justification was really relevant to indirect discrimination, not direct discrimination.
In relation to equality of terms claims, you can justify an inequality of terms.
I see.
And you do it via section 69.
I see.
So this is all further down the line, isn't it?
Yes.
Section 69 is a defence on the merits, which has to be fought out with evidence and so on. And everything we've been discussing so far is really jurisdictional. You say that what the male complainants in both cases actually are complaining of is special treatment afforded to women in connection with pregnancy or childbirth. You say it's excluded. On a proper analysis, it's if I can use the old terminology, an equal pay claim, which is defeated by Schedule 7, paragraph 2. And it can't be a sex discrimination claim either, whether direct or indirect, you say, because of section 70. And that's the end of it. One never gets to section 69 or any other.
Well, to take my lord the Master of the Rolls' question, the short answer is we don't need to look at a defence because there's no operation of this sex equality clause.
Yes.
Because of Schedule 7.
Yes.
I raised it only because it might be relevant to something that is relevant, I think, later down the line. Possibly not helpful at this stage, so if we can just ignore section 69 for the time being, unless we need to worry about it later. Let's worry about section 70, subsection 2, because we say that is what bars a person, that's the mutual exclusivity rule, if you like, or provision. It prevents a tribunal having jurisdiction over any allegation of mistreatment at work in those circumstances.
But in section 71(b), says
What?
that,
One could almost think it said paragraph 2 of Schedule 7.
well, that's what I was wondering, because
But it's in
paragraph
part
2 is actually in part 1 of the schedule.
Part 2 is to do with pension.
Yes. Is that a typographical error?
I did wonder, but I've not found a different version of it, my lady. We can certainly...
But if that's not a typographical error, what is it that then means that you can rely on the mutual exclusivity provision in section 70, even though you're also relying on paragraph 2 of schedule 7?
Well, that's because section 70, subsection 1, is not the usual type of provision that says this section shall apply in the following circumstances. It is one of two ways in which the sex discrimination provision is disapplied. So we're not in the first way, which is subsection 1, we're in the second way by which that provision is...
So we're not in section 71?
No.
We're in section 72?
70, subsection 2, that's
Yes,
correct.
70.
Right, so you say there is a term included which is less favourable, and there is a failure to include a corresponding term,
Yeah.
and so section 70 subsection 2 applies, even though, because of the exception in paragraph 2 of schedule 7, that doesn't result in a levelling up of the terms.
Yes. The sex equality clause doesn't have to have operated in relation to for subsection 2 to apply.
Just trying to understand. I'm just under section 72. So how does this work? Section 66 describes what is a sex equality clause.
Yes.
And that's in the sex equality clause is a provision that has the following effect. That's in 2A and B. And then that seems to be negated by section 72. Neither the following is sex discrimination. How does that work?
Well, neither was sex discrimination. Section 66 is what used to be called equal pay.
Yes. Well, the circumstances which I was describing as activating the sex equality clause, but for the exception, are the circumstances one sees in section 70, subsection 2. Normally,
Yes.
the claimant's won, and he can't also bring a sex discrimination claim and claim injury to feelings.
That you say that his claim falls within section 70 subsection 2, A or B, even if, as you put it, in his case, because of different provisions, the equality clause has not operated to modify his terms.
That's correct. So far, so good.
Can I just intervene at this point? Because if I don't intervene now, by the time I come to speak tomorrow, all of this will have been forgotten about. But on the point that my Lord raised, there is a typo in section 70, 1b, when it refers to part 2, schedule 1, rather than paragraph 2 of schedule 1. Wasn't my lady. The answer is that because part 2 doesn't refer to terms of work, but occupational pension schemes, part 2 cannot possibly be what's referred to in section 70. It must be paragraph 2, because only paragraph 2 deals with terms of work. Part 2 deals with occupational pension schemes. So it must be a typographical error in section 71b. I apologise for standing up now. But
Whether it's a Westlaw error or whether
I will find out whether it's where the error goes if I can by tomorrow.
I'm afraid I only noticed that point yesterday quite late, and what I was going to do is check the originally enacted Equality Act, because obviously if it is a typographical error, well, one can't reread a statute simply because Parliament has failed to write it properly. We'll examine that overnight if we may.
For what it's worth, the Employment Law Handbook also says Part 2.
Yes, but the Westlaw say the same, but I haven't checked the original statute. It doesn't seem to make sense, I have to say, but and that's why you will have seen reference to subsection 1.
Well, the version on legislation.gov.uk also says Part 2.
Be slightly careful in saying got it all wrong.
But as you say, you don't need to go there because you're relying on section 70 subsection 2.
Yes.
Can you give me an illustration of how this? It's all very good at the conceptual level. But can you give me an illustration of how this works? Because I think you're saying I'm just trying to work out the duplication or the overlap between inequality of terms and inequality of treatment.
Yes.
So I'm trying to work out.
Yes.
I mean, there's nothing in section 70 itself which makes that distinction. You've already dealt with, you've gone through your process in terms of inequality of terms. By here saying that there is inequality of terms, it would fall within section 66, but it's taken out by Schedule 7 Part 1.
Yes.
You then say, but I still need something else to deal with inequality of treatment. That's what you say. You say, well, and I get there by section 70.
Yes. To prevent a claim of inequality of treatment in these circumstances, yes.
What I find slightly confusing, but maybe because I'm not familiar with what you're saying here, is that it seems odd that section 66(2) says what a sex equality clause is, and then section 70 says, yes, that they don't amount to sex discrimination.
No. There's, as I said, there's two types of discrimination two types of sex discrimination that the Equality Act outlaws. We spent some time on the discrimination in terms of employment.
Yes, well, I understand.
There's the treatment type claims that are dealt with in section 39. I feel your Lordship may have, your Lordship mentioned section 39(2)A,
Yes.
which I wonder whether it's causing the difficulty, because that's not, in my submission, terms in the sense of contractual terms. That's things like discretionary bonuses, other terms that are in a looser sense provided. It's not to do with an equal terms claim.
It's not to.
It's not. And by far the more common forms of discrimination that are outlawed and complained about are in C and D, dismissal and detriment. But A is not a reference to the equal pay or equal terms provisions.
What's puzzling is what is it, what part of 66(2)A is incorporated in 72(A as being as referred to in the section? It's not, as I understood it, it's not referring to the inclusion of the sex equality clause, it's referring to the inclusion of the less favourable
Yes.
term.
Yes.
So it's saying if there's a less favourable term,
Yes.
like we've described in section 66(2)A, then the effect of that will be that the sex equality clause is read in. That may or may not lead to a modification of A's terms, but whether or not it does, it's still an unfavourable clause included in A's contract, but it doesn't amount to sex discrimination.
Correct.
And similarly for B, the failure to include the clause is a failure that's within 66(2)B, and therefore would ordinarily, or therefore does lead to a sex equality clause being included, even though the clause doesn't, in these circumstances, operate to modify A's terms.
Well, subsection 2 is saying neither of those amount to give rise to a cause of action in a sex discrimination in terms claim, because it's disapplying in effect section 39(2). So it's not disapplying direct or claims of preventing claims of either direct or indirect sex discrimination. It's preventing there from being a breach in those circumstances of the anti-discrimination provision in section 39(2) in terms of treatment. And discrimination, of course, is defined in a number of different ways, which include victimisation, indirect and direct discrimination.
What's the reason? What's the policy reason for that?
For not allowing...
This was my confusion. What is the policy reason for saying that a term which is less favourable, term in A's contract which is less favourable than B's, is not actionable claim for sex discrimination, and similarly a term which is beneficial to B but A doesn't have? What's the rationale for saying that can't amount to sex discrimination?
Well, it has its origins, of course, in the Equal Pay Act of 1970. That came into force in December 75, and that was in part to make us compliant with Article 119 of the then Treaty of Rome. So there was that scheme of equalising terms, and then at the same time there came into force the Sex Discrimination Act of 1975, which outlawed mistreatment.
Is the short answer to my point? Once it's been decided that although there is inequality of terms,
Yes.
but those inequality of terms are justified as a matter of policy or otherwise, you can't, in reliance upon the same matter, advance a sex discrimination claim for treatment. Is that the short point?
It's a short point, so it's a one point. It doesn't need to be decided. As long as a matter of law.
No, I don't understand why. I don't actually understand why the law is as it is.
Yes.
Is that the reason why?
Well, it's just to prevent you from bringing a second type of claim.
Yeah, where it's lawful to have.
Yes.
It's an easy way of putting it. Where it is lawful to have a disparity of terms, you can't rely upon the same disparity of terms to bring a sex discrimination claim for unequal treatment.
That's
Is that
correct.
right?
But also where it's unlawful to have a disparity, you can't either.
Because you're stuck with the equal terms, equality clause provisions,
Yes.
and they either help you or they don't.
Yes.
But whether they do or not, you can't bring a claim for sex discrimination.
Yeah, that's right. It's always been the way for 45 years that you could only bring, well, used to be equal pay claims or unequal treatment claims, and the circumstances could never overlap.
You can't bring both.
You can't bring both.
Right, that's the short.
Yes. And you can't choose to.
You can bring them as alternatives, can't you? You don't, it's not a kind of pleading point that you have to fight one case to a finish and then find that you brought the wrong sort of case. But in the end, a tribunal has to decide which it is.
That's right. I suppose you could allege the two, but they can't both exist at the same time because of the provision I've just taken the call to.
Does that mean that in practice you always have to decide, first of all, whether it's an inequality of terms point? I mean, you could run both together, so if you lose on one, you could But is that, do you always have to run, first of all, inequality of terms?
Well, you don't, but it needs to be thought about, as it perhaps wasn't in the Capita case, because as a matter of law, you won't be able to bring a direct discrimination claim if in reality your claim is one of unequal, sorry, your situation is one of unequal terms. Perhaps they sometimes go unnoticed, as they did in the Capita case. Yes.
Thank you.
Dare I say it, there's a further complication if we turn over the page to section 71. The draftsman was unkind, and there's then this provision in relation to terms that relate to pay, but where a sex equality clause has no effect. Probably better if I let the court read the provision and then make a submission about it.
What do you want to say?
Well, in terms of an unequal pay claim, so a true equal pay claim, but where the sex equality clause has no effect, and this would be one example of that, subsection 2 is activated. And so the relevant sex discrimination provision, which the court will recall as section 39(2), has no effect except insofar as the treatment amounts to a contravention of sections 13 or 14. 14 you can ignore for these purposes, it's to do with combined discrimination. 13 is a definition of direct discrimination. So in
Why do you need section 71 in addition to section 70?
Well, because regrettably, section 71 partly reverses the effect of section 70 brackets 2, that's subsection 2.
Because it appears to allow a direct discrimination case, even though not an indirect discrimination case.
Yes. So if you're PC Hextall, you've got this far down the road. You're now in the territory of section 71, subsection 2. And as I say, section 13, it's a definition. It's not it doesn't make discrimination unlawful. It just defines direct discrimination. That's made unlawful in these circumstances by section 39, subsection 2.
Can you give us an example of a clause to which section 71 would apply?
The classic example is the situation where there's no real comparator. So where, for example, the employee is told, I would pay a male person more than you. Or perhaps even a combined discrimination claim. So he tells a white male employee that he would pay a black female employee more. In those circumstances, section 71, subsection 1 would be activated. Those circumstances would arise because the sex equality clause would have no effect because you haven't got a real living, breathing comparator as required. Then subsection 2 allows you to bring a direct discrimination claim. An example of that is the very last case in the authorities bundle. I don't need to go through it now, but it's the BMC software and shake case in the Employment Appeal Tribunal.
Could you just give that example again? I know it's one that's in some government notes or others.
Yes, but I think it's in the case I just mentioned, but the example, I've actually upended the example. Let me give the example that was given in shake. So the employer tells a black female employee, I would pay a white male employee more than you. She is then in section 71, subsection 1 territory. She has a sort of equal pay claim, but she hasn't got a real one because you need, as I said at the beginning, a real comparator. Now this provision
For section
saves
66.
for section 66. You need a real comparator. Now section 71 then gives her the chance to run either a single discrimination or a combined discrimination claim. Doesn't matter for these purposes. She can bring a direct discrimination claim in those circumstances. And that may actually explain the drafting of section 39(2)A, referring to terms of employment. But it means that her claim is not defeated simply because it would seem to be an unequal pay claim, and it is pay, but she can't find a real comparator on whom to base the comparison to activate the equality clause. Obviously, another example of that would be PC Hextall's case, but it wouldn't help him, of course, because of a provision that the court would have seen referred to in both of these cases, namely section 13, subsection 6b, which looks very much like paragraph 2 of Schedule 7.
So even if he could say that his claim is actually a claim that relates to pay,
Yes.
the sex equality clause has no effect because there's no corresponding term or too much modification to the term of PC 836's terms and conditions would be needed. So he can mount a direct discrimination claim under section 39(2)A in conjunction with section 13, but that's then defeated by section
6b. Well, I don't think his claim could fail because of a problem with having to modify, or it being too difficult to modify his terms in order to gain corresponding benefits. But he is also in the territory of section 71(1), because
so you
the
mean
disparities in
the having no effect in 71(1)B can be having no effect because of the application of paragraph 2
yes,
of Schedule 7?
yes, yes,
Or because there's no comparator?
that's right as well. Yes. Could of course, dare I say it, occur because of the application of the section 69 material factor defence.
So, section 70 subsection 1 is saying that, can we just do A, let's leave out B, because B
Yes.
appears to be a subject of controversy, whether it's accurate or not. But section 70 subsection 1A. So you've now got a situation where there is a sex equality clause, section 66. And it's modified, there's a modification pursuant to that clause.
Yes.
And the effect of section 70 subsection 1 is to say you disregard any sex discrimination provision.
Yes.
You say that that's a case of direct discrimination. It doesn't deal with indirect discrimination. And that's why you need section 71. I thought that's what you were saying.
No, I say that puts an end to any sex discrimination claim. So whether you've won or lost your inequality of terms claim, but section 71 resurrects a potential direct discrimination claim in relation to
it
pay.
resurrects it, I see.
Yes.
So it resurrects it.
From the ashes of section 70 subsection 2.
Yes.
Or section 71A, isn't it?
Yes.
Section 71A.
If it relates to pay, yes.
Then that's direct discrimination claim, I see, either under section 71, subsection 1, or section 72. Is that right?
Either because of section 70, subsection 2. Remember that section 70, subsection 1A is where the equality clause did work. So then you're not in the territory of section 71.
Well, that's a bit of a confusing way to put it, because I thought we'd already established that even if the sex equality clause doesn't work, you still benefit from the mutual exclusivity
Yes.
granted by section 70. But what you're saying is, I think, that even if section 72 does not apply to you because your claim relates to pay and the sex equality clause has, for whatever reason, not helped you, you can bring a section 13 direct discrimination.
No, I hadn't put it, I hope I hadn't, well, I certainly hadn't intended to suggest it that way. We say section 70, subsection 2 does apply. But we say one still has to look at section 71
Yes.
because it will try to save equal pay as opposed to general equal terms claims for the purposes of making them as direct discrimination claims in circumstances where, like us, the sex equality clause has had no effect for some reason.
But you say even if Mr. Hextall makes his way through down that path, he comes to the obstacle of section 13(6)(b).
Well, that obstacle plus he hasn't cross-appealed in relation to that, and he's lost on that
He
issue.
hasn't cross-appealed the dismissal of the direct discrimination.
No, so that's not an issue in our case. But we would also say it's stepping a bit further ahead of the argument, but in fact encroaching on the Capita appeal, but we'd say in any case you don't need to get to section 13(6)(b) because the comparator provision at section 23 means you can't compare PC Hextall with an officer, a birth mother, essentially, someone who gives birth or is going to.
Plus regulation 13.
No, that, I hope I said section 23, which is the, yes, it's in tab 14.
That's the one which Mr. Justice Slade held to be decisive in the Capita.
That's correct. Well, that's correct. So in the Capita appeal, that's decisive, and in the alternative, it's 13(6)(b).
Where do we find 6B and oh, yeah, I see, yes, that's right.
It's probably as good a time as any.
I'm trying just to step back in all this minute detail. So where we are at the moment is you say this is a case where there are dissimilar provisions in relation to maternity, paternity leave. There's no maternity equivalent to maternity leave. So that's where the ET and EAT went wrong in the first place.
Yes.
If you're correct on that, then the next line you have to go through is to say, okay, is there an applicable sex equality clause? Answer, there is. What would otherwise be the consequences under section 66(2) of an equality clause, say, introducing an equivalent provision in somehow or other in PC Hextall contract, in somehow or other providing an equivalence to the maternity leave rights in PC 836's contract. That's dealt with by Schedule 7, paragraphs A1 and 2.
Yes.
That doesn't mean to say that you can then, and it's not then open to PC Hextall to say, well, that may all be so in relation to equality of terms, but I'm still being treated differently because of my sex. And the answer to that, you say, is, well, you can't, you've lost on your what is the true analysis, which is a disparity in the provisions of the contract. Section 70 now precludes you to raising the same points, the same complaint in relation to sex discrimination.
Well, he doesn't have to lose on it. It's a matter of status that that disparity exists, and that puts him into section 70, subsection 2, whether he alleges it or not.
Right, but I mean, the point is he can't, sorry, what I was trying to say was he can't simply rely upon the same matters in relation to discrimination, leaving aside a sex discrimination treatment point. There is still open to him in principle the ability to make a direct discrimination claim, but one, he hasn't appealed against that, and secondly, we've got the equivalent of, he's defeated by the equivalent of paragraph 2 of Schedule 7, to be found in section 13.
Yes, if not more fundamentally by the comparator section, i.e. section 23. We wouldn't want to promote the importance of section 13(6)(b), because we say that's an
So
alternative.
he hasn't appealed. One, he hasn't appealed.
Yes.
Two, no comparator.
Yes.
And three, there's an exclusion anyway.
Yes.
That's how it works.
Yes.
Right. So is that a fair
Yes.
general view of your case?
It is.
Can I,
Yes.
can I just clarify one point? Do you accept that his claim is in relation to a term that relates to pay for the purposes of section 71(1)(a)?
Yes.
You do.
Before turning to indirect discrimination proper, I need to address the absence of a clause like section 13(6)(b) from section 19. And the court will recall reference to this in my learned friends, Mr. Brown's and Miss Harris's Stratton argument, page 54A of their bundle. We arrived at the same destination as them, but we disagree, we took a different route. I wouldn't want my route to be forgotten and for the court to take a route that we would say we can't sign up to. So can I very briefly describe what our position is? I don't want to address it in detail because it's a bit of a sideshow in theory, but in practice. But Learned Friend's point is this, that the old Sex Discrimination Act contained an exclusion like section 13(6)(b), that was a blanket exclusion. It operated against both direct and indirect discrimination claims. They point out that the Equality Act only achieves that in section 13, not in respect of section 19. Where we would agree with them is where they would say, well, the justification provision in relation to justifying indirect discrimination incorporates the concept in any event. Where we would disagree with them is where they say, well, this is governed by EU law, and I'm not doing justice to the argument at all. Governed by EU law, Parliament has made a mistake in not putting it into section 19 as well, or reenacting a blanket exclusion, and therefore when one takes the Marleasing principle of construction and interpretation, one has to read the words in to section 19. To take it very, very, very shortly, we say the Marleasing principle would apply where there's an obligation of EU law that has to be transposed into the applicable UK law, and what they rely on is in fact a derogation from obligations, and therefore Parliament can choose to give employees etc., better rights, and they sometimes do. But we say fundamentally, you don't need section 13(6)(b) anywhere. You don't need it either in section 13 or in section 19. So it's not as if we would win a section 13 claim because we could rely on this defence, but we couldn't rely on this defence in section 19. We don't need to, we say, because of section 23, the comparator provision. But I'm afraid we can't sign up to a rewriting of section 19 adopting the principle in Marleeson. I just put that flag in the ground just so
you
the
don't
court-
sign up to that. You do or you don't sign
we don't sign up to it, and we say we don't need to see a provision like 13(6)(b) in section 19 because it isn't fundamental. Because this sort of claim is defeated by the comparator provision, section 23, whether it's a direct or an indirect discrimination claim. And in any event, as Mr. Burns says, and Ms. Harris says, it would be defeated by the defence of justification in section 19 in any event. You could use the same facts. You don't need 13(6)(b) or its equivalent in section 19.
So you say the old Sex Discrimination Act had a blanket exception
Yes.
for pregnancy, let's just call it that, for both direct and indirect discrimination.
Yes.
The new Act appears only to include it in respect of direct discrimination because there's no equivalent of 13(6)(b) in section 19.
Yes.
But you agree, both parties agree, that within the justification defence to indirect discrimination, there would be the equivalent of it's justified if it's special treatment for women to do with pregnancy and childbirth. So where does, and are you saying that they're saying that you have to arrive at that by writing in the words to section 19 through Marleeson?
No, I think that they say even if you couldn't do that, which we say you can't, you could rely on special treatment for pregnancy and maternity in the justification concept in section 19.
But
We
you
agree
agree
with the
with
latter part, not the former part.
But you both, well, never mind Marleeson, you both agree that whether or not you actually read the words in to section 19, it is possible for an employer to justify what appears to be indirect discrimination on the basis that what they're doing is to give special treatment to women because of pregnancy and childbirth.
Well, lady, that's right, but I must stress that's our secondary point. Our primary point
Yes.
would be that you can't even compare the two. When you look at section 23, it prevents that comparison from being made. So it's our secondary point that you can justify it, primary point that it can never be part of the relevant comparison required either by section 13 for a direct discrimination claim or by section 19 for an indirect discrimination
So
claim.
you only rely on the incorporation in the justification defence of special treatment for pregnant women if you have failed on your, well, they're materially different,
Yes.
and therefore section 23 applies both to
Yes.
13 and
That's correct.
19.
Yes.
Yes.
So it's very much a subsidiary point. So we say, even if you didn't see section 13(6)(b), claims like the one brought by PC Hextall, which failed, and by Mr. Ali, which was defeated in the appeal tribunal, fail because, as in both cases, they fail on section 23 first, section 13(6)(b) in the alternative. So you don't really need section 13(6)(b, is the point we make. We wouldn't want to promote its importance, given its absence in section 19. That absence is immaterial for these purposes.
But if you're wrong on that, then you do say a justification defence, but
Yes.
that wasn't the defence that was brought by the Chief Constable.
That's correct. Maria, that's right.
Can I just go back to the basic point again, slightly niggly? You said that you started off this case as we're dealing with difference in terms point, looking at whether there's a difference in terms or not, and you say there is, when we get to section 66. What is the provision in the Act which says that a discrimination as to the terms of employment which are different is unlawful discrimination if it's not 39(2)(a)? You said we're not dealing with 39(2)(a). What is the discrimination provision?
Well, the short point is there isn't one. You only get to make a discrimination in terms claim under section 66. But remember that section 39(2) is for everyone, not just people who bring sex discrimination claims. It's for anyone with any protected characteristics.
Exactly.
But what you're saying is that the equal terms route doesn't operate by prohibiting conduct. It operates by incorporating a term which you can then sue on and claim, I was entitled to this money. That is my quasi-contractual entitlement, and it operates in that manner rather than by prohibiting the less favourable treatment.
Is that common ground?
I believe that it is.
Well, much of what has been said is common ground. I'm slightly surprised by the length of the submissions on lots of these points.
So that's common ground.
Yes.
So of course, if you're bringing a non-sex discrimination claim where there's a disparity of terms, you might wish to allow in section, or you would wish to allow in section 39(2)(a). You can't if the state of affairs is that which falls in to section 66 of chapter 3.
Right. Yes.
So having dealt with the fairly easy principles, I turn then to the difficult question of indirect discrimination. And I don't say that in any way to be facetious, but this court has, on a number of occasions, got this question wrong. It is a very difficult question. I will need to take some time on it. So the way that the indirect sex discrimination claim is put, let me start by saying this. First of all, since about 2006, police officers have been able to take unpaid parental leave for up to 13 weeks. That's in Annex S of the determination.
30, just remember, 30,
13 weeks
13
of unpaid parental leave.
Yes.
It is very, very, very important in the remainder of my submissions that the court listens out for the distinction in my submissions between parental leave and maternity leave. So the treatment of people as parents is one thing. The treatment of women in relation to giving birth and all its accompaniments, and having a newborn, very young child, and breastfeeding, etc. There's a very different state of affairs. So I draw that distinction straight away. That will be important. As of about April of 2015, the Home Secretary circulated Home Office Circular 11 of 2015, that's at page 58 of the supplementary bundle. I'm not sure if it needs to look at that in great detail.
Just say what it's called again.
It's the HOC 011/2015. I say that because they had that sort of serial number. That's how they're always.
What is that? Is it a regulation or what is it?
No, it's a Home Office circular. The best, well, if this doesn't have a benefit for police officers, then that may cause a great difficulty for PC Hextall's claim, but it's common ground that it has some effect, and we say it's an approval of a shared parental leave right and a statutory rate of pay when you exercise that right. would pose a counterfactual at this point. We would say, suppose we lose in the indirect discrimination claim, what am I to advise the Chief Constable to do to prevent a raft of similar claims? Well, in an ordinary contractual situation, I would say, pay the men the same as the women, or whatever it is Mr. Leach says should happen, or whatever the tribunal said. In this situation, I would say the police officer's terms and conditions are a complete code. We don't see any provision for paying more. So what could I say to assist them with how to avoid a claim? Different if it were an equal terms claim, as my lady pointed out, because that would have the effect of equalising the terms by operation of law. But a judgment of an employment tribunal would result in a great difficulty. We say that is a further justification or a proportionate means of achieving a legitimate aim, namely that the legitimate aim is to comply with the regulations and determinations. That's all we can do.
You just have to try and catch the Home Secretary's eye and get him to issue another circular complying with the court's ruling.
Yes, well, he hasn't yet turned Home Office Circular 11 of 2015 into a determination even now, so I gather other pressing matters.
That could affect our determination of what the law is.
No. Well, I simply say it as a problem that would arise until and unless the Home Secretary gave a determination or approval that allowed police forces to pay more.
Sorry, if I may just briefly, given what Mr. Basu has now articulated when it comes to my submissions, I will be looking to hand up to the court Schedule 22 of the Equality Act, which is an answer to this point. I just wanted to flag that at this juncture.
Can we then turn up section 19 of the Equality Act, tab 14? This is the central provision that an indirect discrimination claim rests upon. That's the definition of indirect discrimination. There are 5 stages.
Give me which tab?
Well, it's tab 14 of the legislation bundle. So as one sees from section 19.1, the first step is to identify a provision, criterion or practice. And it has to be applied equally. It's one that applies equally to men and women. And it's for the claimant to determine the provision, criterion or practice that they rely on. The next stage is a conceptual stage, and that's to identify a pool for comparison. Sometimes that can be a real pool, so all London Underground drivers having to comply with an onerous sliding shift system, for example, then you can just do an analysis of how it affects them, or it can be a conceptual pool that's governed by the PCP. And then the third stage is to apply the PCP to the pool and to see whether that results in men being put to a particular disadvantage when compared with women. And if the answer is yes, then you see whether applying the PCP to the claimant causes that a disadvantage. And then lastly, there's the defence that the PCP is a proportionate means of achieving a legitimate aim. So just turning to stage 1, the PCP itself mustn't be discriminatory. It must be a gender-neutral PCP applied to both sexes. And that would avoid the mistake this court made in James and Eastleigh Borough Council, tab 2 of the authorities bundle. So an example would be...
Mistake of who? This court. Mistake of this court.
Well, an earlier constitution of this court.
If it's binding. It's either binding or it's
Yeah,
not.
but
Well,
it
luckily the House
that.
of Lords
Oh, I
corrected
see.
the mistake.
Is that the swimming pool?
Yes.
evidence?
Yes. Yes. That's the, you must be a pensioner to swim for free, otherwise you pay 75 pence. And pensionable age was defined as being 65 or over for men and 60 for women. And so if you're in between those two ages, it's discriminatory between men and women. Obviously outside those two ages it wouldn't have an effect. But that's direct discrimination.
Mhm.
But it illustrates the difficulty in this concept, that in that case the Court of Appeal thought it was indirect discrimination, introduced that concept themselves, but not the parties, and it's the House of Lords who corrected it and defined it as direct discrimination. So an example
So
of...
an example, oh, you're going to give an example.
Well, so to say that an example of a PCP would be a real one that used to be in place. I'm not sure about the exact height, but you used to have to be 6 feet or something like that to be a police officer, hence why many years ago they were all very tall. Of course, that is going to be indirectly discriminatory against women, because it's going to put women at a particular disadvantage, women applicants, in having to satisfy that criterion. It's applied to both. It's not gender specific, but it's indirectly discriminatory.
So if there was a criterion or practice that shared parental leave was only available to those who were shorter than 5'4", say, then you would say it appears to be available for everybody. In fact, people who share the protected characteristic of being men in the pool are disadvantaged because they're less likely to qualify if the claimant is himself taller than that, and there's no justification for that height restriction, then there's an indirect discriminatory
Yes.
situation.
That would be an example of a PCP with an indirectly discriminatory effect. Yes. So, and that illustrates another point. You're to take the, well, once it's proved that there is a PCP, I hope I can be excused for using that abbreviation. Once a PCP is proved by the claimant, as long as it falls into the category as satisfying the test of being gender neutral, it must be applied as defined. The PCP here is paying only the statutory rate of pay for those taking a period of shared parental leave, full stop. It's perhaps a short point, is my lady's point, that's missing out the thing that would make it have a disparate impact. So taking the next stage, what's the pool for testing? And we say the pool is a concept and not a real thing, but you can prove disparate impact from taking a real pool of people if you have one. But it's a concept which you use to determine whether there is particular disadvantage. And you must, in defining that concept, it's a matter of logic, but in defining it, you must, it must logically flow from the PCP. And all those affected by the PCP must be in this pool, whether real or notional. And so, well, not only the PCP, but the pool has taken a number of forms in the present case, but it was defined for the first time by the Employment Appeal Tribunal in the way I'm about to say. I think that's now accepted by my learned friend Mr. Leach. And it's defined as, and perhaps it's best to take it from, yes, just so the court has it written down somewhere, it's in the core bundle, page 92 in the EAT judgment. Paragraph 61. So at an earlier stage of the appeal, Judge Richardson of the Appeal Tribunal defined it in the way it's at paragraph 61. So those police officers with a present or future interest in taking leave to care for their newborn child.
Yes.
And can I emphasise, to care for their newborn child. When it says to, it must mean, in my submission, in order to. Those words do a lot of heavy lifting. There obviously has a clear meaning. Newborn essentially excludes the adoption cases. Very, very few adoptions will be of newborn babies. So it's clear this refers to people in PC Hextall's position with their own child and their interest in, or with an interest in taking time off to take leave in order to care for their own child as a newborn.
But what was the definition of the PCP?
The PCP was paying only the statutory rate of pay for those taking a period of shared parental leave.
Where is that written down?
Maybe that's page 89. It's in a number of places, but letter D set out there in quite small writing.
Can you do it by paragraphs?
It's paragraph 49, and it's the quotation, paying only the statutory rate of pay for those taking a period of shared parental leave. And it's a curiously defined PCP, because it doesn't contain the sort of element that would obviously cause a disparate impact or put men at a particular disadvantage. I'll come on to why I say that there's two different reasons, or two additional reasons for that. One has to determine who is in the pool of police officers with present or future interest in taking leave in order to care for their newborn child. That pool must be logically relevant, which would be largely a question of law. It will usually flow directly from the PCP, but it's defined by reference to it. Very often the PCP will tell you what the pool is. In this case, the pool selected by Judge Richardson is a logical way of expressing the pool to which, or to whom, this PCP would apply. But when you think about who should go in the pool before you conduct the comparative exercise required by Section 19, you must have regard to Section 23. So when you compare cases for the purposes of Section 19, there must be no material differences between the circumstances relating to each case. So our first point is, well, in no particular order, but one point is Section 23 stops you from including birth mothers, if I can use that phrase, to carry a lot of meaning about maternity leave, childbirth, and its sequelae, etc. Birth mothers must be excluded, we say, because of Section 23, because there's a material difference between their cases and everybody else. They are a unique case. We would say,
Well,
in any...
is the pool people who both share and do not share the protected characteristics?
Yes.
Right.
Yes. It will be a pool of men and women. And the reason I say it's conceptual is that there actually have to be very many people in those categories, but conceptually it needs to include both men and women, because you're applying the PCP equally to both, and you're seeing whether it creates a particular disadvantage on the part of men. So if one sets aside Section 23, the material difference point, even if you set aside that provision, you're still left with the question, when you're deciding who conceptually fits within the pool defined by Judge Richardson, what is the purpose of maternity leave? Does it fall within what's been defined by Judge Richardson. And we say maternity leave has 6 purposes. Number 1, it's to prepare for and to cope with the latter stages of pregnancy. That's going to include the complications and challenges, physical and emotional and organisational, and it will include the considerations particularly of police officers who are on
So it's to prepare for and cope with the later stages
of pregnancy,
pregnancy.
including its challenges, complications, both physical, mental, social, and in terms of employment. Now, if one recalls the position of a police officer like PC 836, supposing she's in the same division as PC Hextall, the roads armed policing team, there will come a time, perhaps early on in her pregnancy, when she can no longer be on operational duties, certainly on contact duties. So it will be a decision for her as to when she starts her maternity leave, depending on how she's deployed and what its effects are on her at work. The second reason for taking maternity leave is to recuperate from the pregnancy. I mean, before I forget, I should say that the first 4 I'm going to name are set out in a case called Hoffman, which is tab 1 of the authorities bundle, and for the court's note, it's tab 1, pages 764 to 765.
That's a Luxembourg. That's a Luxembourg.
That's correct. That's correct. Oh, yes. The third reason why women take maternity leave is to recuperate from the process of giving birth to their newborn, including its physical and psychological consequences. The fourth reason women take maternity leave is to develop the special relationship that's been recognised between a mother and her newborn child. So far, all of those are covered by Hoffman and subsequent cases, which I won't go into. I think my learned friend Mr. Burns will address the court on that in due course tomorrow. We say that's still good law. It's been referred to a number of times since. The fifth reason women take maternity leave is in order to breastfeed their newborn. See, for example, a case called Roca Alvarez, which is tab 16 of the authorities bundle. In that case, the court drew the distinction between breastfeeding, true breastfeeding leave, and bottle feeding leave. What had happened was breastfeeding leave had turned into bottle feeding leave, so that this particular purpose was not served by the broadened legislation which covered both. And it's the sixth, well, sorry, I should have said, it's probably very well known, but of course, breastfeeding will be over a period of it's recommended by the World Health Organization to be a minimum of 6 months exclusively. So it will certainly cover the material period here. We're talking about a maximum of 18 weeks full pay. And the sixth reason women take maternity leave for is to care for their newborn. And it's just the last one that applies to men. And the 5 objectives I've raised before, the one I just mentioned, are not properly met in practice unless there's adequate provision for payment and other terms to alleviate the pressure on the mother, the birth mother, to return to work.
So not 1 to 5 is not adequately met unless it's adequate pay.
Yes.
To induce her to go back to work.
To prevent her from being pressured to have to go back to work. Yes.
So that's it.
There is a good reason for providing what might appear to be preferential treatment in terms of pay for women taking maternity leave. And that is because one needs to firstly encourage these first and enable these first 5 purposes, in particular of taking maternity leave, and avoid disadvantage on the part of women in that position, and address the inequality that flows from taking maternity leave. It's a complex concept, or there's a complex etiology for this, but there is well known to be generally a big gender pay gap 45 years after the Equality Act came into force. You address that sort of disadvantage, or you can address it by providing a benefit to the disadvantaged group. But if you then provide a corresponding benefit to the advantaged group, you defeat the purpose. You re-enable the inequality in question. An example of this would be the Abdullahi and Renault case. It's tab 5 of the authorities bundle. That's a case in which female employees of Renault who took maternity leave were paid their salary. So the collective agreement required them to still be paid, and from the report it appears to be full pay, it's their contractual salary, but they were also paid a bonus of 7,500 francs. And the question arose as to whether that constituted discrimination against male employees who also had children. A number of males made claims for the 7,500 francs multiplied by the number of children they'd had whilst employed by Renault. And to take the point relatively shortly, if we go to the end of that report, so page 543, paragraph 20 of the judgment of the Court of Justice. As the United Kingdom Government and the Commission rightly point out, Article 119, which is the equal pay provision of the treaty, does not preclude the making of a payment such as that in question in the main proceedings, the one I just mentioned, exclusively to female workers, since it is designed to offset the occupational disadvantages such as those mentioned by the defendant. In this case, male and female workers are, in their view, in different situations, which excludes any breach of the principle of equal pay laid down in Article 119 of the treaty. It's for the national court to determine whether that's the case. So in principle, this can be right. It will be for the national court to determine whether it is in fact right in the circumstances. Bear in mind, this case, no, forgive me.
But what was it that the national court then had to consider?
But they had to just decide whether or not the bonus of 7,500 francs for the female employees taking maternity leave was discriminatory because the male employees who had children or who had newborn children didn't receive such a payment.
So what then was the Luxembourg court deciding?
It was deciding whether in principle that would be a breach of the equal treatment provision of the treaty. And the reason for the payment was to offset disadvantages that the women experience because their length of service would be reduced by the time they're on maternity leave. They wouldn't receive pay rises, etc. So they suffered certain disadvantages. And the company rolled up the compensation for the disadvantages into the bonus payment.
Right, so I need to recap where we've got to, because I'm just concerned whether we're now veering off to areas related to justification.
No.
So we're starting off with the identification of the PCP,
Yes.
and that's all those who have been paid the statutory amount for shared parental leave.
It's paying only the statutory amount for those taking.
It's paying,
Yes.
it's paying only the statutory amount
Yes.
for taking statutory leave. It's for the claimant to identify what the PCP is, and they've selected that.
Yes.
The next stage of saying you have to go on and you have to identify the pool,
Yes.
relevant pool. And the relevant pool is all those people to whom that PCP applies.
Yes.
So that will include male or female partners of the birth mother, and it will include the birth mother if and when she opts for shared parental leave. Because those all people are covered.
Yes.
Yes?
Yes.
Right. And I understand where we've got to up till now. And then you've gone into a very long, detailed description about why maternity leave is more than why maternity leave is important and why it needs proper pay. So I'm now trying to fit that into the analysis. We've gone off on that kind of limb.
Right.
What we presumably are looking at here, and you're saying we're not yet looking at justification, so
No.
we haven't got to justification
No.
yet. So what is this analysis aimed at? Because you've identified the pool, you've identified the PCP. What is this part of your analysis doing?
Well, the pool, my Lord will recall, is police officers with a present or future interest in taking leave in order to care for their newborn child. Now, the point I was trying to make is that women taking maternity leave are not in that pool for two reasons. One, the short and easy reason is Section 23, they're not comparable. And two, a connected and longer reason is they're not taking maternity leave, or i.e. taking leave
Is it
for that
women-
purpose.
All right, I'm not quite sure. There are women who, in the future, may wish to take parental leave,
Yes.
shared parental leave.
Yeah.
I mean, they may not at a particular moment of time, but it's open them to do so, whether they are, as it were, currently taking maternity leave, or they've yet to give birth to a child, and may subsequently want to do that. Are you saying that they're excluded from the pool insofar as they want to take maternity leave, or all women who might want to take maternity leave are excluded? Which category of women constables are you excluding from the pool?
I'm excluding those who take leave that is maternity leave,
So,
because it is not for the purposes delineated by
Right,
Judge Richardson
we're
in
going
the
too
pool
fast.
that's agreed.
let me just mark this down for a start. You're saying you exclude all women police officers,
With a present or future interest in taking
right,
maternity leave.
whether present or future, what? Because they may wish to take.
No, with a present or future interest in taking maternity leave.
That could be everybody.
Well, it can only be women.
No, because, but why isn't that all women constables?
Some may not want to have children, some may
Well,
want
we
to
don't know.
adopt.
How are we going to tell that?
Well, that's why.
Well, they've got to have
Only
two.
the
It's got to have
exception-
two. They've got to have 2 weeks compulsory maternity leave anyway, whatever happens.
Yes, but
So I'm just trying to test you're adopting a very wide proposition here. I'm trying to test it. I mean, we know that all women employees are required to take a minimum of 2 weeks maternity leave. So if you're going to exclude any women who may want to take maternity leave, that will exclude all women who give birth to children. That will exclude everybody, unless they've decided they don't want to have any children. But is that what you're saying?
I am saying that the pool as defined does not include birth mothers.
But how do you define the pool then as those police officers with a present or future interest in taking shared parental leave to care for their newborn child? Do you say the error is in saying that it's those police officers with a present or future interest in taking any leave to care?
We are happy with the way it's been drafted by Judge Richardson. We see that's a pretty good
I haven't got to that yet.
way
I
of
think
testing the PCP.
right, I haven't got
The
to
way
that
he's
yet. But we've slightly run over time. We'll have to return to this, I think, when we return. But where I'm leaving it off now, as I understand it, is you're saying anybody who is or wishes to become a birth mother is excluded from the pool.
Yes. Just to introduce the point I'll make after lunch. That's because the pool is not real. It's an experimental lab in your head when you determine the question of particular disadvantage. That alleviates the problem in other words.
2:10.
Right.